The joint enterprise law has been wrongly interpreted for more than 30 years, according to a ruling by the Supreme Court, and there are quite a few implications to this, so we're going to find out more from Joseph Kotrie-Monson, who is Director of Mary Monson Solicitors on Fleet Street. Joseph, good evening.
Evening, Clive.
So can you explain what this means then, this joint enterprise law?
Of course I can. Well, Clive, change today reverses one aspect of the UK legal position on the issue of joint criminal responsibility. A lot's been made of this case in 1984, Chan Wing Soo, which was made by a decision made by the Privy Council, which led to this narrative and evolved into the law affecting joint enterprise murder, which we've heard a lot about in the last couple of years.
So what does that mean when you say joint enterprise? That's you're sort of part of a murder, but you didn't actually do the fatal blow.
Let me give you a little lesson in law school. Law School 101.
Go on.
Joint enterprise, Clive. That law effectively said before today that if a person, let's call them person A, commits a serious offence like murder and intends to do so, the second person B, let's call them, could also be guilty of that same offence merely by being aware that it's possible that A may commit that offence, even if person B didn't actually intend for the offence to take place. So, for example, if person B knew person A had a weapon and there was the slightest possibility that it would be used, then person B could end up being guilty of murder even without intending it to happen.
So would you agree with this ruling then?
Well, in my view, that previous position was, of course, wrong. It meant that someone could be guilty of murder, but only if they intended murder. You know, that main person who committed the murder. But somebody who was with that person and acting as part of the group somehow could also be guilty of murder without intending it, simply on the basis of awareness of risks. Of risk. That can't have been right. I think this brings clarity and proportionality to the law.
Are we going to see lots of cases coming back to court because of this?
Interesting question. I think a lot less than people think. Let's bear in mind that just because foresight and intent aren't the same thing in law again, and some say that's a good thing, that it doesn't mean that if you were aware that something might happen, that couldn't also be quite strong evidence that you did intend for it to happen. So it will still be left to juries in the future, but as far as Court of Appeal cases are concerned, there will be some reviews. But the reality is that the Supreme Court here and the government in general are taking quite a pragmatic view. They don't want people who aren't necessarily what most people would regard as murderers to be taking taxpayers' money, doing 30-year sentence in maximum security prisons. It's very expensive and it's also unjust.